Hello, and welcome to Stowe Talks, a podcast designed to support people going through a relationship breakdown and all the challenges this brings. I'm Matthew Taylor.
And I'm Lisa Gatchell, family lawyers at Stowe Family Law. And today we're looking at what happens to the family home during a divorce or separation. The family home can be quite a hot topic, can't it, Matt?
Yeah.
What do you find are the sort of top worries that people have when they come in to speak to you?
They're huge, and it can depend on the position. Is your client come see you? Have they been in the family home? Are they still in the family home? Are both parties still in the family home? Has someone moved out? Are there kids? Are there not? So everyone's got a very different reaction to it. And I think it's the most emotive of all the assets. People get obviously incredibly emotional about a lot of the separation process, but you don't get emotionally attached to a bank account. Well, I suppose it depends how much is in the bank account. I don't have much of an emotional attachment to mine. But bricks and mortar and in your house and where you've got your memories, where you've had all these important life events happen are really key. So it takes on this kind of totemic kind of importance for people, I think, but that can be huge, wide ranging. And I think there is probably a bit of a stereotype, a bit of a cliche about the mum, the homemaker retaining the family home as a priority. I suppose we'll talk about that in a little bit of detail, but there can be very, very different reactions. But it's usually when you say to someone, and I'm sure this is probably the same to you, okay, tell us about the assets of the marriage. The first thing that people say is, right, our house. That's the number one thing, isn't it?
Yeah, no, definitely. And should we get the boring legal bit out of the way first, as far as sort of ownership of the property and things like that's concerned? So you can own the property two ways: joint tenants, tenants in common. Most people that we come across that are in a relationship tend to own the property as joint tenants. Joint tenants basically means that if either of you were to die, your share of the property automatically goes to the other person, and that's independent of anything that you've put in a will. Whereas if you own it as tenants in common, you own two distinct shares and you can leave your share of the property to whoever you want within a will. And I don't know about you, Matt, but I find that perhaps one of the problems, having bought a couple of houses in my time as well, that the forms that are sent out to people when they're purchasing properties tend to be sort of tick boxes. How do you want to purchase the property? A little bit of a tick box with no real explanation as to the implications, really, of which box they tick. And that causes us as family lawyers quite significant difficulties further down the line, doesn't it?
Yeah, it can cause huge problems if there's an issue where one of the parties has put more money into the house and looking to try and recover that might be doable. If it's a tenancy in common, might be doing it on joint tenancy, but there's a degree to which I think people can get a bit too worried about how assets are held on a divorce, because the starting point is the court's going to look at everything irrespective of whose name. So whether it's joint tenancy, whether it's a tenancy in common. A tenancy in common can be on a 50-50 basis, it can be 60-40, it can be 90-10, it can be whatever proportions are set out in either in the transfer deed or in the declaration of trust. But the court can go over and above those, because the court's got to have an eye. Anyone who's listened to these before will know the sharing approach, so the matrimonial assets, if they are matrimonial assets, and then can invade them to meet needs, so can overreach these anyway. So it can be a big concern. I guess the other way of holding it is when they're in one party's name. So what's the sort of protective steps? Because that can be a worry. If someone comes in and says, oh, we've got the house, but it's in typically his name, what do I do? Can he throw me out? That can be a big worry, can't it?
Yeah, that can be worrying. So if you're married, we can register matrimonial home rights against the property. So by virtue of your marriage, you have a beneficial interest in that property, even though you're not sort of named on the legal title. And therefore, there's a fairly straightforward way of registering that interest at the land registry. The land registry doesn't charge for that. And that sits as a notice, if you like, on the title of the property, so that if the party who owns the property were to try and remortgage it or sell it, it's going to be a notice that there is somebody else there that has an interest in that house. So it's going to cause them some difficulties, and that will remain in place until you get your final order in the divorce, or you have a financial order before that.
Yeah, and so that's some good protective steps, and it's the sort of thing where they'll quite often come to you and say, I've just received this matrimonial homes rights notice. This is like a declaration of war. What's going on? And you kind of say, this is a very standard protective petition. Don't worry about it. We can deal with it. So it's nothing to be too alarmed about. But obviously, the security of having that for the non-property owner is really significant. And particularly used to protect a right to remain in the property as well, and that's technically the kind of, I think it's quite often used so people don't remortgage and things, and to protect the financial interest, but it's technically to kind of allow to show that you can remain and can't be kicked out, because that's the concern, isn't it? As well as, well, it's not in my name. Can you change the locks and throw me out? And the answer is normally no, because there are all sorts of other measures that can be taken to not leave someone homeless.
Yeah, I was just going to say, going back to the joint tenants in common, you're absolutely right as far as the divorce courts and the way that they will look at that. It will, whether that property is, you have a declaration of trust setting out ownership, the courts can still look at the whole of the property. I guess the only thing for people to bear in mind is, whilst we're in this kind of interim period, do they want to review their will? Do they want to sever that tenancy, just so that if something were to happen to them before they had the divorce, they were able to leave their share of the property to somebody else? So whilst it won't necessarily make a difference in the divorce per se, it's still having a think about the impact that could have in it's really morbid, isn't it?
Really
I hate
morbid.
saying the word, but it's like, if you died before you got your financial order or your final order, what would you want to happen in those circumstances?
Yeah, it's a classic awkward end to first meeting kind of thing. Oh, by the way, should we just talk about what happens if you get hit by a bus? Like, suddenly, when I'm doing it and speaking to clients, there are buses everywhere. And this is what happens if you get hit by a bus. And this is what happens if your husband or whatever gets hit by a bus. But yeah, it is all about, protecting your position. And lots of people aren't bothered to say, well, if I pass away, we're on good terms, it is what it is. And some people, it's not quite like that. So it's absolutely worth considering. So once you've sort of, I guess, got to that stage and you've had your first meeting, you're start the process. What, I guess the first thing, before you look at the long term, what's going to happen in the house, about sale and transferring things, how do you cope with managing the house, living in the house, or not living in the house at the same time throughout the process? What are the sort of what we call the interim considerations?
It's really, I think this is one of perhaps the hardest thing, isn't it, where parties still have to, in a lot of circumstances, share a property. It's great if one party has somewhere else that they can go and they're happy to do that, whether that be a friend, family member, or they've got the financial resources to be able to rent another property. But for many people, actually, until the financial settlement's sorted, the financial resources aren't there to enable them to move out, and therefore they end up having to continue living together whilst the divorce proceedings are ongoing. I guess let's talk about if one party does move out. So if one party does move out, a lot of the time the question we'll get asked is, can we change the locks? And the answer to that really depends, again, on the ownership of the property, but most of the time it's no, you can't change the locks. You are both legally entitled to be residing in the property, and therefore without a court order, so that would be usually an occupation order in injunction proceedings, you don't have a legal right to evict the other person. So it's not like, I want to use EastEnders, but often things like EastEnders, they'll be, get out of my house, and they'll have an argument on the doorstep.
Excellent EastEnders accent. I love that. You almost went full Danny Dyer.
Accents are not my forte. They'll have an argument on the doorstep, the locks will be changed, all the rest of it. I mean, in reality, that's just not how it works. As I say, unless there are domestic abuse issues there and you've got a court order, you are both legally entitled to continue residing in that property. That being said, we then look at peaceful enjoyment. So if one party has voluntarily left and they're living elsewhere, the party that's remaining should be entitled to peaceful enjoyment of that property. So, you shouldn't just be waltzing in as and when, you please, coming in at 11 o'clock at night, whatever it is. You should be ideally giving them some notice that you're going to come into the property, you are living somewhere else, that is their home for the time being. If you're living together, then it's ideally trying to work out how you're going to share that property, however that might be. Often the first thing parties will look at is separate bedrooms, how they're going to manage that. Again, perhaps that depends on how many children you've got at home, the space that you have available. And then we look at things like payments. So who's paying the mortgage, who's paying the utility bills, whether you're living together or living separately. Do you want to go through that, Matt?
Yeah, the starting point is that we love the status quo. Not the band, although, but we love keeping things as regular as possible. So if you're under the same roof, you've got the same income coming in. There's no reason why suddenly bills should change. And that, if one party's always paid the mortgage, that party continues to pay the mortgage. That's not going to make a difference to the way the family court looks at things. They're not going to penalise someone for not having paid the mortgage. They're just going to look at, what the mortgage is and what the value of the property. So keeping things as consistent as possible is a really good thing. It becomes more complicated if someone moves out. And I think a lot of it, there's a couple of legal principles. A lot of it is, frankly, a common sense approach, is that you're going to both need to accept there is less money to go around, but there are certain things that need to be paid for. The mortgage has got to be paid, because you default on that, it causes all manner of problems. You've got to pay your council tax, you've got to pay your lecky, you've got to do this. Those aren't the things that should be, that's not where you're looking to cut cloth. Someone hopefully doesn't move out and go and rent this extortionate kind of absolutely blinging rental place that isn't affordable on the budget. You've got to hope that someone's going to be reasonable. That happens, and there are ways of dealing with it. But in most cases, someone's getting somewhere affordable, and you've got to reduce the discretionary spend. And you come to a way, either between yourself or through lawyers, to negotiate and go, okay, the total income between the husband and wife is X, and these are the expenses that need to be met, and that leaves Y in discretionary spending, and that's how that should be separated. In terms of, and that's a common sense approach. In terms of the legal principles, if there are children, then the person who has moved out of the property will, and if the children are remaining primarily with that person, and it's not a straight up 50-50 care situation, there's going to be a statutory child maintenance liability. In terms of the mortgage, this is something that people often worry about. Just because a mortgage is in joint names, it doesn't mean that each party has to pay 50-50. Mortgages are you're jointly and severally liable for a mortgage, which means that fundamentally the mortgage company doesn't pursue, if we were married, so sorry, Lisa, you've got to marry me again for this explanation. If we were married and we'd separated, then the mortgage company isn't going to come after you for 50% and me for 50% if we default on the mortgage. They're going to come after either of us for 100%, and fundamentally, the one of us who had the higher income always easier to pursue. So provided the whole of the mortgage gets paid, it doesn't really matter who pays it. In terms of how that plays with child maintenance, it does not therefore mean that someone who's paying child maintenance then also has to pay half of the mortgage, because they don't have an individual liability for that half of the mortgage. Your child maintenance payments are your child maintenance payments. Now, it may be that in making those payments, there's still not enough to meet the kind of the main bills of the person left in the house. So there may be call for extra payments to be made, and that can either be made by agreement, or you can apply to the court for what we call MPS, maintenance pending suit, or interim maintenance. So for additional payments where the court will go, or you negotiate it, so you don't go to court, but the judge would look at it and say, well, here's what's coming in, here's what needs to go out, here is a fair way for these core expenses to be met in the short term. And that's not going to be paying for lavish holidays as part of your budget or splurging at Christmas. It's going to be for the real core, kind of the essential things with kind of limited discretionary spending. So the bills thing can be tricky. It can be quite costly to argue that in correspondence, frankly. And a lot of the time, I'm sure you've done it, you send letters about who's paying the TV license, knowing full well that the cost of the letter is more than the cost of the TV license for that month. But you're trying to reach some sort of equilibrium, and a holding position is the way to think of it. This is going to be a temporary measure for however long it takes to get things completely sorted. So I think, is there anything else on the interim measures that people really need to consider, you think?
No, I don't think so. I think you've covered most of it. I think the main thing when you're looking at things like the mortgage is to remember that, at the end of all of this, you're probably going to want to either keep the existing mortgage or get another mortgage. And if you're not making the full mortgage payments each month, that's affecting your credit score. And it's not just affecting your credit score, it's affecting the other person's credit score as well. So, it's kind of a priority to keep that mortgage being paid, and using it as a, well, I just won't pay that, and then that will force their hand to do X, Y, and Z isn't necessarily helpful. And actually, you could be shooting yourself in the foot further down the line.
Oh, it's really short-term bad leverage in negotiations. Yeah. It doesn't work. But that's, I guess, a point related to that is sometimes it is just unaffordable. Things happen. Someone might lose their job, and if that happens, speak to your mortgage company. Payment holidays can be great. Just make sure you have those conversations up front. Also, look at your other bills. Are there ways to switch provider for your energy, to fix your rate, that sort of thing, the basic budgeting stuff. We've done a budgeting podcast on here before with Fanny Snake. It's probably worth having a listen to that. You get, when you separate, you should get a single person occupancy discount on your council tax, which is 25%. So that can be a useful extra bit of money. If you separate and previously you weren't entitled to child benefit because you have a higher earner, who means that as a family you fall below the threshold, then that child benefit entitlement can then re-establish itself on separation. So that's something to look at. So there are these extra things about trying to just maximise the income that's coming in by making the most of one.
There may be other benefits available as well. There's some really helpful sort of online calculators, where you can sort of put in your current circumstances, and they'll let you know what it is you may or may not be entitled to, which can be really helpful. So I think it's remembering that, you know, you both have an obligation to be sort of maximising your income and minimising your outgoings as much as possible during this period while we sort everything out.
Yeah, completely. Okay, so let's say so we'll go back to us being married. I've moved out. You're in the house. We've managed to establish how the bills are being paid, and we're sort of rubbing along okay. Well, now, where do we go? Where do we go from this point? How would you then, if you are lawyer Lisa speaking to client Lisa, what are you saying about, okay, now what do we do about the family home?
I think it depends sometimes, and I think it depends sometimes who you're talking to. And I hate to get kind of stereotypical and sexist in this, but often, for example, if I'm talking to a wife in divorce proceedings, they will be very caught up on the family home. It will be incredibly important that they keep the family home, almost to the detriment of anything else.
Mm-hmm.
So sometimes it's about setting expectations. You know, we've seen it a lot over the years whereby, again, stereotyping, but wife will want to keep the house, husband will want to keep the pension, and therefore they just say, you know, we'll offset one against the other. Sounds great in theory. However, where's husband going to live? Because he now doesn't have a house. How's wife going to meet her future retirement income needs? Because she's got a house but no retirement income. And so I think it's about having, you know, not looking at the short-term goals. And I think you said about being emotionally attached to the house, and sometimes people are emotionally attached to the house, particularly if there are children. You know, this may have been the house that, you know, you brought your babies home to, and, you know, that they've been growing up in. But I think it's about trying to expand your horizons and look at the bigger picture, because sometimes actually you might end up with the house. And I know that we've had a few financial advisors over the period that we've been doing this that have come on and talked about how people have been very caught up on keeping the house, and actually a few years later they end up coming back because they've realised that it perhaps wasn't the best financial decision for them, and then therefore further down the line they're looking to sort of sell the property and downsize or move. I know people get very worried about children. Children will adapt to change. It really does depend on how you pitch it to them. You know, if you're saying we have to sell the house because daddy's left and we're getting a divorce and it's all sort of doom and gloom, then obviously the children are going to pick up on that. However, you know, if you sell it and say, you know, we're going to get a brand new house, you can help us pick it, you'll be able to pick out, you know, decorate your new bedrooms, this is all super exciting, then they will adapt much better to that. So I think it's very much about getting financial advice, not being too short-sighted on what it is that you're looking for, and looking at not just you in a year's time, but you in 10 years time, you in 20 years time. Where do you want to be, and how can we set you up for success, if you like, in that? And that can be really, really difficult. And I think it can be really, really difficult conversations for us as lawyers to have with clients as well, because it's often very emotive, it's very emotional, and we are looking at it very much from an asset basis and dividing that up in the most appropriate way. But yeah, I mean, I think that's certainly where I would come from in an initial meeting. And then we would look at, I would certainly try and get clients to look at, okay, this is what would happen if you kept the house, but equally, what would happen if you sold it?
Yeah.
Where would you end up? Let's look at some property particulars. Let's look at your mortgage raising capacity. And I think we would come at it from that perspective. What are the options that people have in divorce proceedings when it comes to the family home?
I mean, typically that the family home is transferred into the name of one of the parties, a buyout of some description, or it's sold, and the equity, the net sale proceeds are split in whatever proportion. Those are the orders that the court can make: sales of properties and property adjustment orders and payments of lump sum, and they're the agreements that are commonly reached. There are a couple of other possibilities. Something that gets mentioned every so often but is super unfashionable is something called a measure order. So a measure order case of Mr. and Mrs. Mesher back in the day, that is where a property is held still by both parties for one party to live in with the children until the children reach normally 18, finish secondary school. The rationale for that being is if there are limited assets and it is impossible for the primary caregiver to rehouse with the children, then under the statute that we look at, Section 25 of the Matrimonial Causes Act, the primary consideration of the court is the welfare of any minor children, so their housing needs come first. Now, when you're talking typically about housing needs for minor children, and this is where there's been a change since the Mesher case back in the 90s, is that the children have got a need for a house with mum and a house with dad. Those are the needs. It is not a house and then somewhere else to go to see their other parent. As parenting has become a bit more equal over time, there's probably been a greater judicial awareness of that. So the problem with the Mesher order is that if there isn't much in the way of assets to go around and there's a mortgage secured against the property, keeping that property in joint names for X years until the children hit 18 mean that the person who isn't living in the house isn't going to be able to get their own mortgage, so they're going to be rented for a long period of time. So for those reasons, the courts don't really like doing them, and then more commonly say, very sorry, but you'll just both have to go into rented. So that's your sort of third option. They're not that common. They also keep ties together financially, which kind of it goes against the steer of the statute, which is you want a clean break and everything dealt with sooner rather than later. And Mesher orders can cause problems down the line when they come to be sold and you relitigate things. So that's the sort of third option. But the main options are they're transferred to one of the parties or they're sold. Can there be a transfer? Well, in a lot of cases, no, because it'll depend on the mortgage capacity. What you need to show is that the person who is going to buy the other one out of the house has got sufficient mortgage capacity to take over the mortgage, unless it's mortgage free, of course, but they need to take over the mortgage, if there is one, but then also pay to the other party, whatever percentage of the equity, 50%, 40%, whatever it might be. That means that they can then go and rehouse to meet their needs or to fit their sharing claim. That can be done if you've got savings, if you've got investment, you've got a bit of cash that you can use as well. But, that's not always an option for everyone. Generally, what the court would look at if it came to the court is how can we both meet these parties' needs? And in so many cases, the fact that they might be in a 4-bed house while they're married and they are to 2 parents and 2 kids, there is no need for that to be retained by one party because one parent with 2 kids does not need a 4-bed house to the detriment of the other person. So they can downsize into a 3-bed, which then probably produces enough money for the other party with a bit of mortgage capacity then to purchase the 3-bed. So that's the balancing exercise that the court's kind of looking at. It will consider all sorts of factors. If you've got kids who are doing exams at that particular time and don't need to be moved out of the area because you can't rehouse in the area, that might be an argument for a bit of a deferred order for sale, a sort of Mesher type thing, or just to give you a year to get through that period. So there are other factors that go into it, but generally the sort of judicial steer, and therefore, when we're talking about court, that's the prism through which we approach everything. So it's a position that I would approach everything when we don't go to court, because most cases don't go to court, is say, well, I think a judge would sell this or would order a transfer, and this is how we do it, and this kind of hits most people's needs. So those are your sort of core options. And I guess there's how do you do that? I mean, the first starting point to that, to know how you can treat the house, is what the house is valued at. And that can be a bit of a mission, can't it, sometimes, Lisa, to actually determine the value of the property?
Yeah, agreeing a value of a house can be a bit of a nightmare. I've got a few going on at the moment, actually, where it's causing a big headache. And I think the problem is that you never truly know the value of a property until you put it on the market and it's sold.
Yeah.
Other than that, it's pretty much guesswork. We have a couple of ways at looking at valuations. I would say probably the most common these days is market appraisals, and it may well be that one party nominates 5 estate agents, the other party picks 3. They value the property, provide a market appraisal, and then we take the average. So that's quite a common way of doing it. The other is that we can look at instructing jointly a surveyor to go around and provide a valuation for the property. But, even when the estate agents come out, I mean, I don't know, anybody that's sold a property will know that you can go around various estate agents and they will give you, it's very rare that they will all give you the same figure. Let's put it that way.
And especially if your property is any kind of unique features to it. If you're on a housing estate and there's lots of similar properties, because a lot of it's going to go off comparable data, isn't it? So if you've got good comparable data, going to be more solid. If you've got a unique property, if there's any kind of listed element, if there's any kind of like, I don't know, I've dealt with some self-builds before, your range of values can be massive, can't they? And typically, one party, if they want to retain the house, is going to say, well, it's definitely the lower value because they want to retain the asset at the lower value. And the party who wants the buyout from their interest is going to say, no, it's definitely the top value. So it can be really problematic, can't it?
Yeah. And they change regularly.
Yeah.
When we're looking at court proceedings, the court proceedings go on for months and months. And in that time, a property value can go up and down. And it may be that the valuation that you had at the beginning has to be changed by the time you get to the FDR. It has to be changed, re-looked at again by the time you get to the final hearing. So we have a bit of sort of moving target syndrome, if you like, when it comes to evaluation. I mean, ultimately, if the parties can't agree, the court will either look at the market appraisals and say, well, we think the price should be this one, which will usually be the median value, or they'll instruct a joint expert and both parties are kind of stuck with the valuation that comes in from the joint expert.
Yeah. And then similarly, you're looking at that change, you can get equivalent changes in mortgage capacity because basically the sum that you're looking to do when you're trying to see if a house can be retained or sold or how people meet their needs go through is percentage of equity from the house plus mortgage capacity equals buying power. So that's your two parts of the equation, and the value of the house can change, but the value of mortgage capacity can change hugely. I think if you look back, to around the time of the sort of Kwasi Kwarteng Liz Truss budget, and then interest rates go absolutely bananas, which means that mortgage capacity drops because people are borrowing at a lower rate. That was a real time when someone's mortgage capacity was dropping like a stone on a monthly basis every time the Bank of England reduced the base rate. Increase the base rate. So there are all those factors to play that tie into things. So it's not necessarily fixed. I think you said something quite interesting and that I completely agree with, that you don't know the value until it sells. The value of something is what someone will pay for it. So when do you sell the house? If you're going to sell the house, if you come to the conclusion, look, neither of us can buy it out, we don't have the mortgage capacity, it exceeds our needs, we're going to sell, we're going to split in whatever proportion and move on. When do you do that?
So just before we started, it became quite apparent that Matt and I don't agree as to when you should sell the house. So what I'll do is I'll go through when I think you should sell the house, and then Matt can interject.
And then I'll tell you why you're wrong.
Ideally, we should sell the house once we've got the financial order, because it's only at the point that you've got your agreement in place that you know how that property is going to be split. And so as accurately as you can, subject to, as we've said, the house actually selling for a price that's been predicted, how much you're going to be getting for it. So it's only at that point that you can really crystallize how much you're receiving from that, and therefore, with your mortgage, what property you can look at purchasing. And the idea then is that ideally you would sell the property and be able to move straight into your new homes without any issues. The alternative, and Matt will tell you why this is the correct way, I'm sure, in a minute, is that you put the property on the market straight away. And for some people, this might be their only option. For example, if they simply cannot afford the mortgage payments moving forward, you put the property on the market straight away and it sells before you've reached an agreement. I would say that the risk, I'm going to preempt you now, I would say that the risk of this...
Absolutely getting your rebuttal in here first. This is
I know.
Deeply unfair.
I would say that the risk of this is that if you sell the property before you've got an agreement, it would be incredibly risky for the net proceeds of sale to be released to you. Because if you, for example, split it 50-50 and then ultimately at the end you agree that it should have been 60-40, one party may have already spent or dissipated the money that they've received, and therefore you're not going to be able to get that back. So in those circumstances, what tends to happen is that money has to be held by the conveyancing solicitor often, or one of the family solicitors, pending you reach an agreement, which could be a number of months down the line. And in the interim, you've got to find housing, storage for furniture, etc. So I'll pass over to Matt and he'll tell me why I'm wrong.
I don't think you're wrong, but I take the view that get it on the market as soon as you know that it is going to be sold, and as soon as you can afford to do so. And the reason why I say that is because divorce proceedings take a long time. 12, 18 months as an average, can be longer. Selling a property takes a long time. Bare minimum, you're looking like, 6 months really. You might go a bit quicker if you're very lucky and there's no chain and cash buyers, but you're probably looking 6-9 months. So if you wait till the end of the divorce process to get the house on the market, and then you go through that whole process, you're suddenly running up against 2.5, 3 years. I think that it's quite rare for a property to actually sell and complete before there's an agreement. It happens, it does happen, and then absolutely you should hold funds. And you shouldn't agree distribution until you know what there is to offset any departure from the quality that there should be. If it's just the house that's the only asset, then I accept you're not allowing people to rehouse, and you might just fritter away capital on rent or whatever in the interim, so that might not be appropriate. But in a lot of cases, I think getting the property on the market can be a good thing. One, you get bids. You know what it's going to sell for. Because people are making offers. You get an estate agent saying to you, this is a good offer, accept this. Once you get that process, you're still looking months to do the conveyancing. You might need you can say to your purchaser, look, we're getting divorced. It's going to take a little while. We ain't moving that quickly. Your purchaser might still be trying to sell their property. There's a big chain. Things can go wrong. So you can wait and you can drag out the process a little bit. That's not a speedy process, and you can make that work for you. I think there is something cynically that encourages a quicker settlement. If you know that the property is on the cusp of selling, if you know that there's cash sitting in a conveyancing account ready to dole out when it's done, that's the sort of thing that kind of focuses minds and effort. It's also less uncertainty. If you know what it's going to sell for, then rather arguing about, well, I think the house is worth 325, and someone saying, I'm sure it's worth 350 because look at this one that sold that around the road. Rather than arguing over that extra sort of 25 grand, you know what it's going to sell for, and you can base your figures, and you say, with that property, with that money, we can buy this property and that property. So with some caveats that it absolutely isn't suitable in every case. I think that for a lot of people, getting it at least on the market, even if you're not necessarily completing the sale, could be really advantageous to move things along, to give a bit of certainty and a bit of consistency. So that's what in my learned submissions, that's why I'm right.
In my submissions.
Thank you. But I do accept that if you've just got if your only asset is cash from the house and that is tied up in the conveyance account, then you both got to rent. That's not a situation that's going to help because all you're doing is amortizing that capital. You're going through it.
Or if one of you is that's a bad term, isn't it? The weaker party, but the weaker financial party, if you like, then I guess the risk of having the money held will put pressure on, but it may perhaps put the wrong pressure in that it forces you to agree to something that perhaps you wouldn't have done, and it's not necessarily in your best interests.
Yeah, I think that's right. I think, it's not, I'm not trying to say that is right for every case, but I see a lot of cases where I just think, get on the market. Let's crack on. Because either there's some other assets or someone's can stay with family, or you say to client, look, can you move? Can you do it? Can you, oh yeah, I suppose I could go and stay here, so-and-so, and actually, so I think it's something worth, there's no cast iron rule. And if either of you wants to retain the house, then obviously it's not going on the market. I mean, you can't do that.
And you do both have to agree for it to go on the market. I think that's another question we get. Can they sell it out from under me? I mean, you do both have to agree. You both have to sign the documentation. So unless you've got an order for sale, there's nothing that you can do.
Yeah, it's quite hard to force an order for sale. And I think this is something that people are concerned about, is how do I get a house sold if I'm not living there anymore? And it can be tricky. It can be really hard. There's stuff that you get court orders and you can enforce those court orders. And you can go back to the court for an order that someone... This is one of my favourite little applications. Is when if someone won't sign documentation to get the property sold, you can apply back to court for an order that they have to sign it, and if they don't, then a partner of So Family Law can sign it. That's a really useful trick. But it's extra time, it's extra cost. You probably get your costs for that application, but it is. If someone's being difficult, it makes life difficult.
Yeah.
That, I think, going right back to what we said, I think a lot of lawyers will say, well, don't move out the family house, because if you do, then you're going to struggle to get it sold. Sometimes that's appropriate in some cases. Sometimes just the actual grind of being in the same house overrides those concerns for a lot of people, which I can absolutely get behind.
Okay, Matt, I think then to end the podcast, as we always do, best thing would be for you to give us some top tips on dealing with the family home. Okay,
so my top tips, I think, really important thing, go right back to what we were talking about at the start, is sort out your kind of interim financial position. Be sensible. Don't have a big battle over it. just take a step back and make sure that you can come to some kind of mutually acceptable arrangement where the bills are getting paid, you're able to maintain things, and it doesn't blow up and cause World War III, because so much time, so much money can be wasted on those interim arguments, which really are to last a 6, 9, 12-month period. So that's my sort of first one. And then apart from that, this is kind of in the spirit of my let's just crack on approach. Get your valuations nice and early, get your estate agents around. I'm not going to say my top tip is to put it on the market straight away. That is case specific. But I think it is important to get the values early and get your mortgage capacity early so you know what you're dealing with. What about you? What's your top tip when dealing with the family home?
I think the main one is just to manage your emotions. So try and look at it from all avenues, get some financial advice, work out what your mortgage raising capacity is, and work out actually what will be better, what will work best for you both now and for you in the future, because actually it may not be what your heartstrings are initially telling you. Okay, so that's it for this episode of Stowe Talks. Thanks for listening. If you would like more information on our podcasts, head over to stowtalks.co.uk and please rate, like, share and review this podcast where you can.